Ladies, my lord, I'm not going to be long. That's the good news. The bad news is I'm going to repeat a little bit of what I said before the break. I hope I might be forgiven for that. It's just I want to provide some clarity, really, to be absolutely clear at least what the appellant's case is, because it does address some of the observations that were made by my lady in conversation. And obviously it's important. It's just very important that we address this particular point. Yeah. So, again, I started, and I'm just going to remind the court about it again, with paragraph 43 of Ms. Parker's evidence, because it really does make important reading. This is where the justification for the difference in treatment is explained for the first time.
That's the third point, isn't it?
It is the third.
It starts at 40.
Yeah.
And you, 41 rather. At 40, she says there are 3 points.
Yeah.
And she repeats that all over the place, 51, 52, and 53,
exactly.
57.
And those other 2 points I'm going to deal with very quickly at the end, but I'm going to deal with what I respectfully submit as the main point.
Comparative disruption, is that your point?
Yes.
Okay. Those likely to face the most financial disruption.
Yeah.
That's your 43 point.
The way the other 2 points are put, I would respectfully suggest as well that if we undermine this of the 3 justifications put forward, then we've gone a very long way in establishing the appellant's case. So, just to be clear again, it starts with the premise that the DWP has a primary responsibility for ensuring that people who need financial support from the benefit system are able to get it. It's got to be practical, effective and efficient, of course, but then this has meant focusing DWP resources on those who are likely to face the most financial disruption from the start of the pandemic, and also adopting a flexible approach to the way that the benefits are administered. So the exercise undertaken is to identify who's going to suffer the most financial disruption as individuals who need assistance from the DWP. So the first point I make is this is not a general comment about disruption in the economy. This is about individual households and families. Then, of course, we know that the assessment made at that point is targeting people who are going to lose income or have lost income as a result of the pandemic, rather than those who might have faced increased costs. And then in parenthesis, which could not have been calculated accurately. And then they say, I note the claimant's evidence that they have faced increased costs, but that's common to lots of people. And then it says, the government focused its response on those who had lost income, etc., as it considered that they were likely to face the greatest financial disruption. So there's a clear statement of conclusion there. And then the additional benefit, or the ancillary benefit, this also assists in providing a cushion to individuals who have suffered short-term loss of employment or reduction in employment, but who would be expected to return quickly into the labour market. So, first task, identify who's going to experience the greatest disruption. Okay, that means we prioritise them. Additional benefit of prioritising them, bounce-back-ability, or however we want to describe it, the cushion. So what if the premise is wrong? What if the assessment about who's going to suffer the most financial disruption is wrong? And to the extent that we're answering that question, my lords and my lady, we are not ships passing in the night here. We are addressing the fundamental prior question. Would it mean that the ancillary benefit, i.e. the benefits to the economy more generally of having people come back into work, was so important that the DWP would have still persisted in the difference in treatment, even if aware that in fact new claimants coming onto universal credit were better able to cope? Or indeed, if the DWP was aware of just how badly those who aren't going to get the uplift were able to cope, i.e. disabled recipients of legacy benefits. We don't know the answer to that question. We don't know, for example, if the Secretary of State would have said, well, actually, we've identified the people who are going to suffer the most. It's disabled claimants who are receiving legacy benefits. But nevertheless, we're going to continue with our policy. because of the additional benefits of bouncer-backability or the cushioning? Or would it have meant something different altogether happened, which is that the Secretary of State decided to help both groups, both those who are likely to face the most individual financial disruption and those who might benefit from the additional support for the purposes of the more general public interest? We simply do not know the answer to that. Acknowledging, as Miss Parker does, that everybody is going to face increased costs is not to the point, because the evidence is about the balance of the burden of increased costs. Disabled people higher, new UC claimants more able to cope. So there's no acknowledgement of that point. These are, and again we're talking here in general terms, but these are very specific hardships for people which would have to be acknowledged. I'm not going to go through the evidence, there's plenty of it before you, about what this actually meant for disabled people in terms of increased costs, in terms of the use of food banks, etc. There is one statistic, for example, which is that 6 in 10 of people who are using food banks in 2020 were disabled. That's 3 times the national average, and indeed the Trussell Trust also said that 1/3 of the people using their food banks were on legacy benefits. So these very serious hardships would have had to be grappled with when one asks the question, who faces the most financial disruption? We say this means that there is no relevant decision by the Secretary of State for you to have regard to and defer to. And moreover, with respect, we say we don't have the benefit of a judgment below either, because Mr. Justice Swift did not engage with these issues. Paragraph 34 simply does not address the question of comparable disadvantage.
He says they're distinct. Those points are distinct, doesn't he?
Well, with respect, my lady, I think he actually doesn't even say that. He mischaracterises the claimant's case. He says, well, people on legacy benefits have got low levels of income.
Yeah.
Now, that is true. We did make the point that historically benefits are at an all-time low, near enough. But that was the beginning of the point, not the end of the point. The point was what the impact of the pandemic, which is ultimately what the focus is, on those very same people. Being disabled, they were disproportionately adversely affected by increased costs. It's the double whammy point. Not only were they disproportionately affected by the pandemic and the virus itself, they also suffered increased costs and were offered no additional support from the government to address those. And we say it's also not possible for this court to conclude that it's plain that even in the face of what we now know about the respective levels of disruption, the cushion effect or the bounceability issue would have justified continuing with this difference in treatment, because we have no evidence about how effective this £20 was in achieving that secondary benefit. We have none. Mr. Brown said in his submissions that the DWP had been vindicated. There's no evidence for that. Mr. Brown, of course, cannot give evidence himself. What we can't do is simply lump the £20 uplift with the furlough scheme and say, well, look, the economy did okay in the end. Now, I do appreciate that, ultimately it might not be possible to prove every counterfactual. I understand that. But there should be some evidence which addresses not only the implications of what we now know about the balance of disruption, but also what we do now know about the efficacy of the measure itself. And that has profound implications, not only because it's not available to this court to reach its own determination as to whether or not the balance was fair and proportionate in circumstances where the Secretary of State has not done that exercise herself, but if we don't know, moreover, how the £20 worked, if indeed it did, to improve cushioning or bounceability, we don't know whether it was justified in not also giving it to people in comparable positions, i.e. those on legacy benefits. The only thing that's said about this is at paragraph 53 of my learned friend's skeleton, where they say that the continuation of the uplift for people who came on to UC in March 2020, the duration of the measure helped them avoid arrears and debt and adverse implications for their mental health. All such matters which would understandably have been achieved for those on legacy benefits had they also enjoyed the benefit of the extra £20. And this isn't just a point made by reference to the appellant's assessment of what the policy ought to be. This is DWP policy. If you look at Ms. Parker's statement at paragraph 14, page 55.
Sorry, can you give me the reference again?
Paragraph 14, page 55. It actually begins on page 54, I apologise. It's there directly addressing ESA and explaining that even though you're on ESA, you're expected to work if you can. And that last sentence, this reflects the government's position that welfare should facilitate work for the entire population. So it doesn't provide on its face an ostensible reason to discriminate between those on ESA or those on universal credit, new or otherwise. Now, we of course do not say what ought to have happened or should have been done. We don't dictate what the policy should be here, and neither is it for this court to do so. We simply say, on the evidence before this court, this difference in treatment is not justified. Various points my learned friend says, well, they're saying we should have increased it, we should have done that. That's not, we don't need to go that far with respect.
No, you don't.
Ultimately, if the court finds that justification is not apparent on the evidence, it will be a matter for the Secretary of State to decide what to do that, and there's copious authority to that effect. But we would invite you to consider the balance of evidence in relation to the efficacy of the measure, alongside what we now know about the balance of disruption, and conclude on that basis alone it's not justified. But of course the court will also keep in mind the other important points about, for example, the very high number of existing universal credit claimants who got the payment too. Nothing about that is said other than to say, well, it's an accidental side effect effectively. Well, it has to be considered when one looks at whether or not people on legacy benefits are facing a disproportionate burden for the benefit of the public interest. You'll keep in mind the double whammy on disabled people that I've already mentioned, and the lack of parliamentary consideration of the matter. As my lady correctly pointed out, there were of course three reasons provided: cushioning, practicality and messaging. I think you have my submissions on messaging really, that could have been done at another point. On practicality, my learned friend made this position. He said, well, you can't actually say that the Secretary of State could have done something else, because that's to move away from your discrimination case. The discrimination case is you didn't pay the £20 for legacy benefit claims. That, of course, constitutes the difference in treatment. But the question and the balancing exercise in relation to proportionality of justification could, of course, take into account what other steps were taken to ameliorate the hardship being experienced by those facing the most disruption. And it's hard to believe this claim would have got off the ground. The Secretary of State said, well, we can't do anything for you by way of an increase in the personal allowance, but we're going to give you a one-off payment or something of that kind to try and make up for it. Precisely the sort of measure they do in other contexts. Again, ultimately, how the Secretary of State addresses an unfair difference in treatment is a matter for the Secretary of State. But we would just make the points that there's really nothing hard-edged about what's said about the practical problem. At its very, very highest, it's said that whilst the decision to increase by the routine amount legacy benefits on the 21st of November 2020 had to be made then in order to effect a change that didn't come into force until the 1st of April 2021. We made our points earlier about how that seems a particularly generous timescale, considering that we knew by the 4th of January that there was going to be a further uplift. But all that speaks to is that how difficult it might have then been to introduce an in-year payment, i.e. not an in-year one-off payment, but an in-year increase to the personal allowances. And it says that there are risks associated with that, but they're not specified or identified, although I take, of course, my Lord's point that they are there.
Well, they're there and the evidence was accepted, wasn't it? The evidence of Kirsten Parker was accepted.
Yes, I mean, insofar as we can't challenge it, but it's not a trump card, is what I'm really getting back to.
Because what's the...
Well, it might explain why decisions couldn't be made at the right time. We say, obviously, it doesn't explain the failure to, one, do a one-off payment or indeed make an in-year payment and face
this is a challenge to the 2021 regulations. You are challenging the failure to introduce an uplift for the disadvantaged cohort at the same time as the uplift was continued for the advantaged cohort.
Yes. Well, what we say on that is that that's the difference in treatment that we say is unlawful. Yeah. The way of affecting that may have been to do a one-off payment, for example. There's nothing to suggest
but that's about remedy. What you're saying, a remedy could now be fashioned.
Yes.
But we are looking at the justification for not giving the extended uplift to the disadvantaged cohort. And one of the reasons is the practical and technological difficulties of doing that whilst preserving the security and reliability of the benefit system.
Yes, and of course we accept that. I'm not trying to move away from that.
Sounds like you are, Mr. Burton, but explain why you're not trying to move away from that.
Well, because the absence of any offsetting measure, if indeed it is correct to say that you couldn't have an equivalent increase, goes to the question of the treatment. It goes to the question of whether or not the Secretary of State struck a fair balance. So if it's correct to say that in January, when they realised there was going to be a further lockdown, and they realised they were going to extend universal credit, and if indeed the practical problem was the only reason why they weren't going to try and help the people most disrupted, then the natural thing to do was do what they've otherwise done before and since, which is say, what other accommodation can we find? And that doesn't happen. So it goes directly to the question of whether or not the difference in treatment is justified.
So they not only shouldn't... No, I've got it. Okay, thank you.
There are many differences in treatment we see in many cases which are justified by reference to other things that are done to try and offset the disadvantage. Can I put it that way?
Yeah.
And we don't have any offsetter policy here, and there's no argument that one couldn't have been done, even if it would have taken a different form than the precise form of the difference in treatment.
Yeah.
I can put it that way.
I've got it. Thank you.
I mean, ladies, my lord, I think that's enough for me on the substance of the case. There were a number of other points made about sort of reviving questions about cherry picking and analogous circumstances. We say they're not relevant to the task before the court, not in any material way, but they are, of course, covered off in the skeleton arguments that were before the court below. And so if you are interested in the appellant submissions on those, I believe they're all contained therein. May I just turn my back to one?
Yes, do.
Unless I can assist any further at this stage.
No, nothing from the court. Mr. Burton, thank you very much. Thank you to both leading counsel and, of course, to those sitting behind. We know how much work goes into preparing these cases, and you have assisted us by the way in which you've prepared this case and the clear focus of your submission. So we're very grateful. We will be reserving our judgments. When they are ready, they will come to you electronically for typographical corrections only and not to re-argue the case. Please be conscious of the contempt warning in light of the Bayes decision earlier this year. That is a heightened warning. We hope that as having received our judgments, you'll be able to agree any consequential orders and that there will not be any need